All right, I think we'll go ahead and get started and people can come in and join us as we go. For those of you who haven't joined us for one of our prior webinars, my name is Alyssa Zenz. I'm the pro bono counsel at Dorsey & Whitney, and I also serve on the board for Legal Corps. And Legal Corps is a nonprofit organization that exists to connect small businesses, minority-owned businesses, small nonprofits with volunteer lawyers, meaning that the lawyers that they can provide for you will offer their legal services free of charge. And our biggest thing that we want you to take out of today is knowing that you're not alone during this time. We're here to help you. We want to help you rebuild. And there's a whole network of attorneys across the Twin Cities. This webinar specifically was organized by lawyers at Dorsey & Whitney, where I work, but Legal Corps has a list of volunteers from law firms across the Twin Cities. And so we really are all here for you. We hope that you'll reach out after today as well. We hope you'll go back and watch our other webinars on different topics that we've had. Those will all be available to you on the Legal Corps website. And if you have any problems finding those, you can reach out to me. Everyone should have received an email from me with the PowerPoint. And so if your video or connection isn't playing nice, you should be able to find that in your email. If you're not getting emails from me, let me know in the chat function here, and we'll make sure we've got your email address written down correctly. And throughout the presentation today, you are welcome to submit questions through the chat function. I'll be watching those, and we'll have a Q&A session at the end of each of our topics. And we are happy to answer those questions today, or you can email as well. And we are happy to connect with you later directly if you would prefer to ask your question with one of our attorneys. And so I am first going to turn things over to Dan Gilchrist, who's an attorney in our real estate group. He focuses on commercial real estate law and real estate finance law. Thanks, Dan.
Thanks, Alyssa. As part of this program, we're going to be talking primarily about real estate leases and the building our communities. If the next slide, please. And we'll also touch on supply chain issues as well. So the focus on real estate leasing, we're going to spend a lot of time just talking about lease provisions and how they might apply to damages or rent issues or various issues that we think that you may want to hear about. But again, there'll be a question and answer session. So please give us your questions in the chat or by email later. So we're going to talk about repairs and replacement obligations under the lease. We're going to talk about insurance requirements under the lease. We'll talk about casualty provisions within a lease, which party is responsible for repairs and what other rights might be available if there's a casualty affecting the lease premises. Force majeure clauses, which may be relevant in a time of pandemic or with damages to property, and then miscellaneous as well. And then there'll be another part later in the program about supply chain issues. Next slide, please. So in every commercial lease, there's probably a section called the tenant repair obligations. It might have a title, tenant repairs or condition of premises, but it generally gives it governs the obligations that the tenant might have with respect to repairs or condition of the premises. Unlike residential leases, commercial leases do not have implied covenants of habitability. The landlord is not required to make repairs inside the premises unless it's actually stated in the lease. That's different from residential leases. So in commercial leases, what's in the agreements that are in the lease control. So it's very important to read the lease. And I'll be mentioning that as we go on here. So in many cases, in a standard commercial lease, the tenant is required to maintain and repair the inside sections of the lease premises. It's just kind of a typical, but again, each lease is different and you have to read your lease. Now, that particular section could be overruled by the casualty section if there's some damages to the property, and we'll talk about casualty issues later. Sometimes single tenant buildings often require the tenant to conduct building maintenance or exterior repairs and the like. So look for that in single tenant building issues, that there's expansive tenant obligations. Now, with respect to these tenant obligations, landlords have various enforcement options. And so landlords have more options than tenants quite a bit, and they could include self-help, which means the lease might allow the landlord to do the tenant's work on behalf of the tenant and then send an invoice to the tenant, and there's eviction and lease termination. Next slide, please. So you may have a question, well, what about if you're a tenant anyways? What about the payment of rent? If I've experienced some damages or if I don't have access to the premises, do I have to pay rent? And again, the answer is often found just in the lease itself. So you have to read the lease. Every lease is different and they're all negotiated. Some commercial leases contain protections for tenants if the lease premises become unusable, and primarily that's if the premises is damaged. And so you'll look into the casualty section to see what availability the tenant have to not pay rent. They'll call it rent abatement. Sometimes if there's lack of access to the premises, there may be some rights in favor of the tenant that could affect whether or not rent is payable, whether utilities are available, or if there's a condemnation. In the case of damage, and I'd mentioned this above, the casualty section is where you want to look, and we'll talk more about that. Except for those types of exceptions, the tenant's obligation to pay rent is independent of the landlord's obligations under the lease to make certain repairs. So just keep that in mind that absent provision to the contrary, you have to pay the rent. The tenant should pay rent. Now, I say that with a caveat because there are other opportunities that are outside of the terms of the lease that we could talk about if anyone needs information on that. There's a concept of if you're unable, if constructive eviction, if you're unable to use the premises at all because of the landlord's actions or inactions, then you might have some sort of case. But that's a litigation. Next slide, please. So each lease also may have a section that has the landlord's repair obligations. Again, each lease is different. They're negotiated. Some are not negotiated. So you may have to look to the lease to find whether or not the landlord does repair obligations. What I see typically, the landlord's repair obligations are structural components of the building, perhaps the roof, the foundation, maybe exterior maintenance, things of that nature. Typically, like I had said, tenants are responsible for inside the premises. There's less often there's rights of tenants to enforce the obligations against the landlord. Now, that depends on how the lease was negotiated, but it's rare for the tenant to have remedies to terminate the lease or get or provide self-help. But it's possible that could be in your lease. So again, you want to look for that. Next slide, please. Along these lines, so you've found the provisions of the lease, you know whose obligation it is to repair, or you know that perhaps if you're a tenant, you might not have an obligation to pay rent. So it's important to enforce these lease obligations to the best you can. You'll have to have the lease, of course. If you're a tenant and you don't have the lease, just ask the landlord and provide a copy. Every landlord keeps electronic copies, and so you should be able to get that. But from a landlord's point of view, there's always a remedies section, and there's a litany of remedies that the landlord has under the lease, and they're under the default section typically. From a tenant's perspective, there's less often a tenant's remedies section, but you can look for that, and if you find one, then it might say that you have to give the landlord a written notice alleging the default of the landlord and allow the landlord a certain period of time to remedy the alleged deficiency, and then after that, it might be vague as to what your remedies are if the landlord doesn't cure the default. But it's important to prepare a letter with a clear statement of the claims that references the appropriate lease provisions as support. And then there's another step. A lot of commercial leases will have a notices section that specifies to whom the notice should be delivered. It'll have the name and address of the actual person that can receive notices for the landlord or the tenant. And then there may be delivery requirements. And this could mean that you might have to send the letter by FedEx or certified mail, depending on what the lease notice section says. And then finally, is an important concept is that if you are talking with the other party, whether you're landlord or tenant, and you come to an agreement as to how a certain issue is going to be resolved, whether it's partial payment of rent or whether it's one party has agreed to make a repair within a certain period of time, it's important that that be reduced to a writing and signed by both parties in the form of a lease amendment. Real estate leases, unlike other contracts, oral leases would not be enforceable. If it's a real estate lease, you have to reduce it to writing. So that's an important point. Another concept I think that may be applicable to some of you is my business is no longer viable, or the premises needs some repairs, or things along those lines that require perhaps a lease termination. It's always better to get a written lease termination agreement than to assume that the lease is terminated, perhaps because of an agreement you might have exchanged in a text or anything along those lines. And there's also a lot of open issues that need to be finalized. So a written agreement to terminate a lease, if that's what the parties desire, is pretty important. And you put in who owes whom what, and what happens with the property that's in there, and the various other components that are open issues all should be put into such an agreement. The next slide, please. Now, Megan Flynn here is going to talk about insurance clauses within real estate leases, and I look forward to any questions on the matters that I discussed. Thank you.
Thanks, Dan. So I'll be getting into the very exciting world of insurance and casualty clauses. Again, it's going to be really important here that you read the lease. The lease is going to tell you who's responsible for what and whether insurance was required on the property. So a question that you might have is, who's responsible for maintaining insurance? And again, the lease will state whether it's the landlord or the tenant or both that are responsible for maintaining insurance. Without getting too far into the weeds, there's two main different types of leases. A gross lease, where the landlord typically pays for all of the building's taxes, insurance, and maintenance. And usually the landlord will be responsible for maintaining insurance on a lease in that case. There's a net lease, where the tenant is responsible for all of the additional costs associated with the property. Or more commonly, this is most likely the situation, there's a modified gross or net lease. And in this case, both the landlord and the tenant are responsible for certain maintenance costs as well as insurance costs. So the types of insurance that are typically required under a lease vary depending upon the terms of the lease. Generally, we'll see some of the following. There's named peril policies, and those typically apply to specific instances such as fire or flooding or things like that. There's all risk policies, and those generally cover all types of damage to the property, except for those events that are specifically excluded. There is commercial general liability insurance, and in that case, that covers the tenant or the insured for any negligence caused on their part. This doesn't usually cover any third-party damage that's caused to the premises. And then finally, there's personal property insurance, and that would cover specifically what's in the tenant's space, their own property, and any improvements that they've made to the property. Next slide, please. So a deductible, who's responsible for paying the deductible? The deductible, as you are probably aware, is the share of the insurance claim that you're required to pay before the insurer provides coverage. So you usually will be required in a lease to have a certain face amount of the policy, and the deductible is what you're required to pay until they pay out. So again, as Dan said, read your lease. It may say which party is responsible for paying the deductible. It may not. If it doesn't have any sort of agreement, usually it's the party that's insured that would have to pay its own deductible. Or that's something that might be stated in your policy. Another type of insurance that we will see in a lease is something called business interruption insurance. And that will cover lost rental income in the event that you're unable to operate the business as a tenant. It will cover potentially a move to a different location. And it's usually not sold as a separate policy, but is included in one of these all risk or comprehensive policy packages. Next slide, please. These are a couple of sample insurance clauses. This is a landlord's insurance clause here at the top. And in that particular clause, it is pretty landlord favorable. It's not requiring the landlord to cover anything, really. It's up to the landlord's discretion. But again, it provides all risk building coverage if the landlord so chooses. In addition, it also says that the landlord's not obligated to cover any personal property. And in this case, usually when we see a clause like this, we'll have the tenant covering most of the insurance costs, including their personal property and some sort of all-risk property insurance if it's not covered by the landlord. Below that is a sample business interruption insurance clause that, again, in this particular one states that the tenant will be covered for 1 year if they're not able to operate their business. And this will pay some of the costs of rent as well as salaries in case the tenant's property is destroyed. Next slide, please. This is a sample tenant insurance clause. This one requires the tenant to have insurance on their personal property in subheading A there. Subheading B requires business interruption insurance. C is comprehensive liability insurance. And that, again, just covers the tenant in the case of negligence. So in this particular clause, there is not any all-risk property coverage. So typically, we would have the landlord covering that on this side if you see a clause similar to this. Next slide, please. So in addition to the insurance clauses, you'll also see what's called a casualty or damage and destruction clause. And what that does is it outlines the rights and the obligations of both the landlord and the tenant if the premises are destroyed during the lease term. And within that clause, you'll usually see some of the following. So there's tenant's notice obligations. This will tell the tenant how soon after the damage occurred they have to notify the landlord or vice versa. It will usually cover repair obligations and will state whether the landlord is required to repair all of the improvements and to what extent they're required to make those repairs if the property is damaged pretty significantly. So in some cases, you'll see that if the damage is over a certain percent, then the landlord might have the option not to make those repairs and instead might be able to terminate the lease. And I'll get to that in a moment. These clauses may also cover casualty caused by the tenant. And in that case, that would be if the tenant started their own fire or something happened as a result of the negligence on the part of the tenant, then usually casualty clauses won't come in and allow some of these remedies. Next slide. Termination in the event of casualty. So in this case, again, look to the language of your lease. It will state whether the tenant or the landlord has the right to terminate the lease. And it will usually depend on the extent to which the premises are damaged and how close you might be to the end of the term of the lease, or the amount of time that it would take to repair all the damages caused to the property. So sometimes it will state a certain number of days, sometimes it won't. But again, look to the language of your lease to determine whether or not the landlord or the tenant is able to make that call. And then finally, abatement of rent. This again here is whether the tenant has to pay rent if their property is damaged. Usually the tenant is allowed to withhold rent until the repairs are made by the landlord or until restoration of the premises have been completed. Next slide. And here's a sample casualty clause. This one requires the landlord to restore the property. And again, it allows the tenant to hold off on paying rent until the repairs are completed. It also allows the tenant to terminate the lease. And in this case, if the repairs are going to take longer than 120 days, then the tenant can terminate. Or if the landlord is unable to or decides not to complete the repairs within that time period, then the tenant's able to terminate the lease. This is a pretty tenant-friendly provision. Usually it will be to the discretion of the landlord as to whether or not the property's been damaged to the extent that the repairs are possible or not. And usually they get to make the call whether or not the lease can be terminated. But ultimately it's going to require you to look to the language of your lease to determine who gets to make that call, whether you're obligated to pay rent, and on whose terms get, or who gets to make that decision, the landlord or tenant. Next slide. Next up we have Will Elliott, and he'll be covering force majeure.
Yeah, thanks, Megan. My name is Will Elliott. I'm an associate in the firm's real estate group. And like Megan said, I will be discussing force majeure. Now that's kind of a weird word. You probably haven't heard that before, don't even know what that means. A lot of leases, or at least some leases, take into account really unforeseen events. Specifically, some leases will even take into account the occurrence of a riot or civil unrest. And they set forth rights that the parties will have in the event something like that occurs. So I have a definition of what force majeure is there, but basically just think of it like you really would not have anticipated this would have happened, but it did. So now what do we do? Common examples are natural disasters, floods, fires, earthquakes, but you also see things like wars and acts of God and labor strikes. Recently, it's been discussed a lot in light of the COVID-19 pandemic situation, and landlords and tenants have been wondering if that, does a pandemic account as force majeure? So that's, maybe you've already looked into your force majeure clause recently because of that. But today we're going to focus on whether it helps you in the event of what's going on with the civil unrest and riots the past few weeks. So if we could turn to the next slide, we'll kind of discuss how to figure out if it's going to apply to you. Not all leases have force majeure clauses, so that's step one. Do I have one? Just take a look in your lease and see. It will very likely be called force majeure at the heading of the paragraph. If not, it might be called excused delay or unexcused delay, but again, force majeure is the most likely definition of it. If your lease doesn't have headings, then just look inside the paragraphs for terms like acts of God, floods, earthquakes, and you'll find it. The most important thing you want to look at is most of these clauses are going to list specific events. They're not just going to use general language. They're going to list out things that are going to trigger force majeure. And so you're going to want to read your list. If it just says earthquakes and acts of God, that's probably not going to be good enough. It's not going to apply in this situation. So you're going to want to look for a phrase like riots, looting, civil commotions, civil disturbance, insurrection. If you see fire and your building was damaged by fire, then it could apply. Acts of military authority, those are all phrases I've seen in leases. And the argument could be made that the events of the last few weeks fit those descriptions. Okay, let's go to the next slide. So you found a force majeure clause in your lease, and let's say it said that riots is a force majeure event. So what does that mean for you? Obviously, it's going to vary if you're the landlord or the tenant, but generally speaking, I would say Most leases are not going to let the tenant stop paying rent because a force majeure event occurred. So let me say that again. If riot is in your force majeure clause, you have the force majeure clause, that's not going to let you stop paying rent, most likely. But it is going to allow the parties to delay their performance in other ways. For example, say, you signed your lease already, but you haven't taken possession, and the landlord was agreed to do some work to the premises, and they were supposed to do it by the end of the month. The landlord could then say, no, I can't complete it by the end of the month. I'm entitled to a delay equal to the length that the riots lasted. Or say the landlord was going to come in and do some maintenance, or say the tenant had an obligation to do maintenance on the property and it was agreed that they were going to do it within 30 days. Those deadlines, those dates where things were supposed to occur by, all get extended. So if you have that riot clause, if you have the force majeure clause, and you need more time to get something done under your lease, raise the force majeure argument and it will likely work. Now, granted, all leases differ. And like I said, most leases aren't going to let you stop paying rent. So we're speaking in general terms here. There's exceptions to all of these. If you have specific questions about your force majeure clause and what you want to do with it, feel free to reach out to me directly. My email is here in the PowerPoint. But now that you kind of get the idea how it works, I think the next slide is an example. Yeah, so here's a sample clause. I'm not going to read the whole thing with you. You guys will have the slides. But I think this one is kind of common. We'll read the first two lines there. It says, in the event that either party is prevented from performing or is unable to perform any of its obligations under this lease. So that's that idea. Something unexpected happened and you just can't meet your deadlines, or you just can't do it. So we know we're talking about force majeure here. But then look in that parentheses right after that, other than a payment obligation. Okay, so that just told us that the tenant can't stop paying rent, but that other deadlines, other obligations under the lease, whatever they may be, can be delayed due to this clause. Then when you get down a few lines, starting on the line 3, 4, 5, there comes the list of what's included. It starts with act of God. That's probably the most common. And then you read through acts or decrees of government or military bodies. Okay, maybe that might apply. Fire, that might apply. Then you keep reading, and I bolded there in the middle, riot, insurrection. All right, that very likely applies. So you have a valid force majeure clause that's going to excuse performance, going to allow for delays. You see there, I bolded down a little further down, performance shall be excused. And then I'll just highlight in the last sentence of this clause is something that is a little unique, but do keep an eye out for. It says from the third line from the bottom, regardless of the excuse of force majeure, if such party is not able to perform within 90 days after such event, the other party may terminate the agreement. That's unique, but it may be in your lease, so just take a look. Keep in mind that if you want it out of your lease and your lease allowed it due to a force majeure, you could raise that argument. Let's look at the next example. All right, this one works differently. It starts off with our list of what qualifies. It says strikes, lockouts, labor disputes, blah, 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 blah. And then you keep reading all through that whole list, and that not once does riots occur. I see governmental actions is in there. That's kind of vague what that means. And then the last thing I bolded is other causes. So if you have one like this, it's going to be a lot tougher. Not impossible. You really have to get into the weeds then. If you have a list of events and it doesn't sound like one of them's right on point, it's going to be tough, and there's a lot of nuances to whether the clause applies. Again, feel free if you want to send me your clause and I can take a look and help you, but a clause like this, I would say you're going to have an uphill battle of using this as a defense for a delay. But let's keep going, just highlight a few other things. Again, there in the middle, it says, except with respect to the obligations imposed with regard to rent and other charges to be paid by tenant. So what's that? That's telling you, again, is that tenant cannot say, I'm not paying rent. Force majeure does not usually allow tenant to stop paying rent. Yeah, I think that's it for that one. You get the idea. Each clause varies. It's just keep it in mind. Take a look in your lease to see if you have it. Let's go to the next slide. All right, so I was just trying to think through generally what else could show up in your lease, because all leases are so different. You never know what you're going to find that could be applicable. One thing that came to mind is a lot of leases have somewhere in the lease itself, it says landlord is entitled to establish its own rules and regulations, which tenant then must follow. Then they might give you an attachment to the lease, or at the back of the lease is a list of rules and regulations that you have to follow. Take a look in there is just one idea. Because there you'll find more unique type provisions. Recently, there was the story in the news with the Midtown Global Market where a tenant was kicked out of their space for racist and offensive speech, and turns out that there was a clause in their lease that prevented that type of stuff. So look out for something that prevents, offensive, discriminatory, violent behavior, just in case, you have a tenant who has been doing something like that, or there might be something in your lease that could help you out. I also saw a lease recently where landlord expressly reserved the right to prevent access to the building in case of a riot or a mob was the language they use, and that was again found in the rules and regulations section. So if you're in the middle of a dispute, whether you're landlord or tenant, and it was landlord boarded up the doors, boarded up the windows, and tenant wanted to be in but they couldn't, again look in the rules and regulations and see if there's anything that governs access or something like that. You never know what you're going to find in your lease. So these were just examples. You're probably not going to find clauses exactly like that. It's just my way of letting you know that it is worth reading the whole lease at a time like this, or at least look at the headings and see, hey, maybe that's applicable right now. I never would have imagined it when I signed it, but sure enough, we're in unique time. So just take a look. And that's all I have. And that kind of concludes the first half of our, well, more than half of our presentation, the real estate portion. So I think next we're opening it up for a Q&A. Is that correct?
That is. Thanks so much, Will. And I haven't seen any questions come in yet through our chat function. I'm going to just give you a minute in case anyone wanted to get that opened up. If you're on a computer on Zoom, if you kind of click on the bottom of your screen, there's a More tab. And if you click on that, you can open the chat. So if anyone does have a question, they can put it in the chat panel there. Or I also have my email up if anyone wants to email one. We'll give you just a minute, and if no questions come in, we will move on. Our next speaker is Michael McCormick, who's a partner in our corporate group in Minneapolis. He focuses on contracts that businesses use to buy and sell their products and services, and to develop new products, and protecting their rights and things they can create through intellectual property. Today, Michael is going to talk about aspects of a supply chain arrangement that businesses that you might be facing now during this period of rebuilding and unrest. So I didn't see any questions come in. So Michael, I'm going to go ahead and turn things over to you.
Thank you, Alyssa. I'm very happy to talk to you about supply chain issues. When we thought about this program, we thought that there may be some businesses who will face questions about buying the products and services that you need to operate. Maybe also you're on the selling side of that, selling products and services to consumers or to other businesses. And we try to think about what might be of interest as you're facing those questions. I think that for the most part, these things probably won't be very different from what you were doing before. There may have been an interruption in your business. You might be dealing with the kind of real estate and insurance and other issues that we're talking about in other parts of this program. But as we thought about it, for the most part, it seemed like the way you were buying and selling things before will probably be pretty similar to the way you do things running forward. So, of course, we'd love to hear through the chat function or send an email to Alyssa if there are specific things that feel different now. And we'd be happy to give you our thoughts on how to handle those situations. As we thought about this, thought it might be helpful at least just to remind people about how these buying and selling arrangements typically work and how you can address issues that might be important to you, get advice on those if you need that. So that's what I'll be talking about for the next couple of minutes. It won't come as any surprise that a common theme when you have a group of lawyers talking is that a lot depends on the specific documents that you have, the contract documents that create the relationship between you and your supplier, your vendor, or maybe your buyer. And as I thought about that, I thought that there's sort of a rough way to divide those things up. One would be simpler, more routine arrangements are often handled with relatively simple looking purchase orders. Maybe they refer to standard price lists, standard terms of delivery and payment, other sorts of things that are a bit more routine and result then in invoices that are printed out on forms and emailed, maybe mailed to trigger payment. Software that you get access to might be subject to a standard end user license agreement document that you just click on when you accept the terms in order to use the software. A lot of those documents will refer to separate terms and conditions that are the legal terms that govern the relationship. They might be called standard terms and conditions. That's pretty common. Sometimes those are attached to the documents that you were looking at. They're included with a purchase order that someone sends who's wanting to buy things from you. They might be included on an acknowledgement form when you place your order. They also might just be referred to and be somewhere else, and often that's on the website of the buyer or seller, whoever it is whose terms they're trying to get to apply. This can lead to a collision where maybe both parties have their own terms. Each one says, hey, my terms apply. The buyer says that, and then the seller says, no, mine do. And that can lead to a bit of confusion. No easy way to summarize how those things get worked out. But a key thing is to look to see what documents are there and read them for any important terms. Figure out if there's a reference to other standard terms someplace. It might be the documents that are in your hand or that sent to you by email look pretty simple, but if they say that they are subject to other terms, they refer to other terms, they incorporate them by reference is a common phrase, then those documents are actually bigger than they look, and they include those other things that may be hiding somewhere else. The question, of course, will be whether any of those terms are negotiable or whether any of those terms raise any issues for you. And you can only tell that by reading what they are. And the question about negotiability is a theme with all of these kinds of documents. That's going to depend on your relationship with the other party, the type of product or service that's involved. If these are for routine, smaller volume purchases, you're probably not negotiating too many points in that transaction, but maybe you can look at the payment terms. And if they want payment 100% in advance, you could say that's not something we're willing to do. Negotiate for 30 days, negotiate for 60 days, or something else. You go to the next slide. Thank you. The possibility, of course, is that there are more complicated arrangements. Maybe because the products are custom made to your specifications. Maybe they're high volume commitments that are going to spread out over time. Maybe they're long-term commitments. Maybe they're really mission critical products that you need to buy or you need to supply to someone so that they're there on time and they work properly so they can get built into a bigger product. Maybe you're a franchisee and you're working with a franchising company. All those sorts of things can lead to more complicated documents. Maybe those are master purchase agreements or master service agreements. They might be custom software license agreement, all those kinds of things often are negotiated more specifically. They're probably not that frequent. Most companies might have a couple of those, and they might have a lot of the more routine, simpler kinds of supply arrangement documents. So for these other ones, the same issue applies. Where are all the terms and conditions? Again, as lawyers, we know that what's written on the page really governs. That's most important. And when I say page, it could be electronic format, of course. That's going to govern. It would be only after that that more that other doctrines in Minnesota law would apply. But the roadmap to the way the relationship will work will be found in the documents that you enter into, and those can be put together from a number of different pieces. You may have an invoice and an acknowledgement form that need to be read together. You may have standard terms, some places need to be read together with the purchase order. So give you a bit of a process. Same issue applies as to what is negotiable in a complex relationship or longer term relationship as in a short one. Locating those documents, figuring out what they say. If documents have been lost because of damage to premises or for some other reason, it's certainly possible to ask for a copy. And consider whether in any of these cases, getting some advice from a lawyer would be helpful. We'd be, of course, delighted to help with that, and Legal Corps and other resources in the community are available for that as well. You could go to the next slide, please. Key terms that will come up in all these arrangements mostly won't come as a surprise to people who are running businesses and buying things. Of course, the starting point is just a description of what the goods are that are being purchased. Maybe it's services, maybe it's cleaning services, or it's security services, or it's a web hosting service for your website. Really important to check that the basic description of what the documents cover and tell you you're going to receive is correct. Of course, pricing also and payment terms go hand in hand. Maybe these things refer to standard price lists that are printed somewhere else. Maybe you can negotiate price. Maybe you can get negotiated volume discounts. Payment terms I mentioned already, the number of days to pay in advance. Definitely look at that and look at whether there are late fees that apply if you pay late. Those things may or may not be negotiable. In the end, what you're going to do, even if you feel like you're looking at contracts where you can't negotiate changes because of the negotiating power that you have relative to the other side, maybe you don't have enough volume, or these products are standard products. Maybe it's a huge supplier and they don't negotiate with customers. You can at least be well informed about what it is you're stepping into and compare that arrangement to one that you might get from another provider of similar products. And then maybe you can improve your position without negotiating changes, but by trying to select suppliers who give you better terms. Delivery terms as well. Just the basics of when the products will come, where they'll be delivered. There can be a lot more detail there, of course, if you need custom packaging or labeling, if you need maybe your own business labels applied, those sorts of things. The next slide, please. Warranties are important, of course. Those are the legal terms that relate to, does the product do what you expect it to do? What was agreed that it should do? Will the services that are provided give you the results that you're expecting? Often those are very standard from vendors, but if you're looking at more customized products, you might think about the basics of whether the products will meet the specifications. Are they going to serve the particular purpose that you have in mind? If they don't, what's the remedy? It's a really important question. This is a very practical issue. If something has gone wrong, can you send them back for as a return and get a replacement? Can you get a refund? Look at how those issues work if you're facing questions about some products that don't meet your expectations. Also, how long the time period is to do that is very important. If you're the seller of goods, you want to be sure that you've included special language that limits the warranty you're giving. That is an aspect of law here in Minnesota and quite common throughout the country, that you need particular wording to avoid warranties that otherwise are going to apply to the products that you sell, or disclaim those warranties is the term we use. And for that, it's worth checking with a lawyer if that's going to be an important part of your selling of products. Again, on mechanics of how this works, think through the return process. If there's a problem, the amount of time you have to inspect and accept any goods that you've received, what the mechanics are to send them back. Those things should be laid out someplace, and in reading through them, that could be a practical part of the way this works for you. Force majeure, we heard about earlier, how these contracts are affected by events that are unforeseeable, out of your control. Similar in these kinds of transactions, the usual result would be, if there is an event of force majeure going forward, that there might be a time period then that's extended for the seller to deliver the goods to you, or potentially for you to pay for them. That can be tricky, and it's quite common that force majeure clauses in these kinds of transactions don't excuse the obligation to make a payment. The theory on that being that even if there is an event, whether it's a fire, a flood, an earthquake, unrest, that businesses can figure out how to get to the bank or do online banking or something and make a payment. So that would be something that's specific to the contract. And then risk allocation in the back of standard terms, in the back sort of part of the contract, often where people read the lease, there can be provisions that limit liability, usually in favor of the party that wrote the document. So if you're buying goods and the seller is using their standard terms, there's probably something there that's going to exclude legal liability for them for a variety of things that could result if the goods aren't what you expect. Again, whether those things are negotiable or not, it's a big open question in standard contracts. But it would be wise to be aware if you're dealing in goods that could create problems if they don't meet your expectations, then to at least be informed about what the contract says about when you could go back and try to get a remedy from the seller. I think those are the high points that we wanted to hit on the vendor arrangements. I wish you all great success, and I know we'll be very happy to take questions if there are any.
All right, I haven't seen any questions come in. We'll give you a few minutes. Feel free to pop some in now. I do want to announce, I did put it in the email this morning, but we are canceling Friday's session, which was just meant to be a kind of a catch-all Q&A wrap-up session. Our office and a number of offices, I think, around the Twin Cities will be closing for Juneteenth. And so we want to honor that holiday and take that day off. But we do really encourage you to reach out to us if you have follow-up questions about any of the issues. And when you go back, if any of you are going back and watching replays of our other programs, if questions pop up there, do let us know on that as well. So I'm not seeing any questions come in, so we'll go ahead and wrap up for today. Thank you for joining us, and good luck as you take on this rebuilding process. Thank you.